Are you all in São Paulo now?
No, Cesar is in Brasília.
César em Brasília. César, eu acabei de escrever um artigo sobre o PL, viu? Vou mandar para você. Mas um
legal.
artigo para jornal, assim, tem umas coisas. Hã?
Vai para qual jornal?
Não sei, ou o Jota, ou o Conjur. Eu vou mandar para você. Aí você me dá um retorno. Bom dia a todos e a todas. Vamos começar então mais uma live da nossa série de lives sobre regulação de mercados digitais. E hoje a gente vai ter o prazer de receber o Lazar Radic, que a Bianca vai fazer a apresentação dele, mas o importante é que o Lazar ele está conduzindo e liderando uma pesquisa ampla sobre regulação ex ante de mercados digitais em diferentes países, né? E isso vai abrir um pouco a nossa perspectiva. Nós temos focado muito na análise da regulação europeia e no projeto de lei, e depois as nossas discussões que são mais teóricas, elas entram em temas relevantes para essa regulação. Mas é interessante ver a pesquisa do Lazar, que existem, inclusive, motivações diferentes nos diferentes países para essa regulação, que acho que vai ser uma contribuição muito importante. Então, a partir de agora, eu vou mudar para o inglês e passar para a Bianca, para que a gente possa ouvir o Lazar e depois discutir um pouco, no tempo disponível, algumas das suas primeiras informações que ele traz dessa pesquisa. So, thank you very much, Lazar, for joining us in this live and bring your expertise and the first findings of your research. I will leave the room first for Bianca to make your presentation, and then we start our live. And after your presentation, we will leave some time for discussion and for questions so that you may make more clarifications about your outstanding research. Thank you very much. It's really a pleasure to have you here.
Lazar, good morning. Really a great pleasure to have you with us today. Lazar is a senior scholar for competition policy at the International Center for Law and Economics and an adjunct professor of law at EA University. Lazar is also a very qualified lawyer and has worked in Band 1 law firms in Spain and Serbia, both in the competition law department. He holds degrees in law and political science from the University of Madrid, LLMs from the University of Amsterdam, European Union and International Law, cum laude, and the European Union University Institute, Comparative and International Laws. Lazar's PhD, also from the European University Institute, explored the intersection between political policy, philosophy, and competition law. And today we are going to talk about the regulations of the enforcement, the difficulties of the enforcement in DMA, the designation of the gatekeepers in Europe, and a lot of other matters, and also about our project, our bill 2768 of 2022. The show is yours, Lazar.
Thanks, Bianca. Thanks, Juliano. Thanks, Cesar, for being here. Thanks for inviting me, and thanks for agreeing to speak in English. My Portuguese is not that good. I understood some of what Juliano said. I might repeat some of what he said, but please bear with me. So as Juliano and Bianca anticipated, I'm working on a research project that is looking at the global trend towards ex-ante regulation, something which also affects Brazil, given Law 2768, which is currently being considered in Parliament and being discussed. And we, of course, have the father or the author of that bill with us today, Cesar Matos. Now, perhaps it would be easiest for me to share my screen because I have a presentation prepared that could aid you in following what I'm discussing. Okay, let me just send you a request.
If you can send your presentation for us after, Lazar, for us to put in the illegal grounds site in the internet, if
yeah, of course,
it'd be great.
Did you receive my request to share the screen?
Not yet. Francisco, have you received his request? Lazar, if you want, you can share with me, and then I can.
So I can also perhaps share it in the chat. Here we go. Let's try to make it like this. Okay. So here it is in the chat. Maybe you can share it and we can go from there.
Okay, let me open it. It's downloading.
But as I was saying, generally, this project was initially going to be a short publication of 15 pages, and once we began, we realized that there was no way it was going to be so contained. So it went from 15 pages and being one thing to being several sort of pieces of about 50, 60 pages, of which today I'm going to talk about the first. So as you can see on screen, the first part of this project, which aims to explore digital ex-ante regulation from a global perspective, so taking into account not only the European Union, the US, but also Brazil, Australia, South Africa, Turkey, all these countries, and I don't know if your listeners are aware, are in some way, shape, or form trying or playing with the idea of adding another layer to competition-like regulation, which adds and perhaps even deviates from standard antitrust practice. This is what I refer to when I talk about ex-ante digital regulation. Typically, platforms were subject to competition law, which is a general legal framework that applies across the board to all industries. Now, some industries like telco or railways have traditionally been subject to public utilities regulation or sector-specific regulation, but that was not really the case for what is broadly defined as digital platforms. Now, just so the listeners also are on the same page, what is generally meant by digital platforms are, for example, things like Google search, things like Amazon, things like Apple's iOS or App Store. And now there is a trend to say, well, competition law can't address certain issues that arise in these product markets, so we need additional regulation. So all this to say that our goal and my goal was to understand the similarities, the rationale, and you can go, yeah, the project, we're here, yeah. What does it all mean? Are all these countries coming from the same place? Do they aim to achieve the same thing? Are there any commonalities and differences? Obviously, this is happening very, very fast. Just 2 years ago, a year ago, nobody had or was considering almost an ex-ante digital regime. Now the European Union has passed the Digital Markets Act. That's the pioneering act, so to speak, of its kind. And now many countries seem to be following suit. The EU, Germany has reformed its competition law. The US was considering several bills, ICOA, the American Innovation Choice and Online Act, the Access Act, the Open Apps Market Act, or OAMA. None of these have been passed, and they're all separate bills, but they have been under consideration. They're not dead yet. Australia has ran several inquiries into digital platforms, very long, very detailed, to ascertain whether there is a need for DMA-style regulation. When I refer to DMA-style regulation, basically I'm referring to ex-ante digital regulation. I'm saying digital, I'm saying DMA because that's the pioneering legislation that other countries are trying to emulate. Canada seems to currently doesn't seem likely, but you never know. But they have considered and have published several reports. South Africa in July or August, I believe, published a report recommending additional powers, presumptions, and per se prohibitions for digital platforms. Brazil, as you know, is considering Act 2768. Turkey has an amendment proposition to its Competition Act, which I believe is Law 4059, if I'm not mistaken. South Korea has amended its Telecommunications and Business Act, and Japan is also considering some sort of business-to-business fairness-oriented regulation, although both of these are more contained to the DMA. The Japanese proposal, for example, applies or would apply to app stores. Saudi Arabia, other countries, who knows what will come up tomorrow. Now, the overarching research question was, or is still, what are the commonalities and differences across these ex-ante regulations? Or, put differently, is there a common understanding of what ex-ante regulation seeks to achieve, how it seeks to achieve it, what presumptions it should incorporate, and how it should go about those objectives? Now, there's also a normative component. The project is not purely descriptive, but I do think that it is necessary to understand what is going on before we attempt to assess it through any given normative framework, right? And I guess that is the first step also in this project. Now, I am going to break it down, or I will break down the project in 4 or 5 parts. The first one, which I will discuss today in more detail, is the goals and rationale. After that, I plan to focus on gatekeepers. What is a gatekeeper? Is a gatekeeper, or is the concept of gatekeeping consistent across jurisdictions? Is there an economic or legal theory of gatekeeping? Or are these just companies that are active in certain sectors but not others and have certain turnover, which might be fine, but we need to understand if there is a sort of cogent thread underlying it. Next, I will focus on prohibitions and exemptions. What is not allowed, and are there any circumstances in which would be allowed, such as efficiencies, safety, security, or privacy considerations. And finally, there is an ongoing debate about the enforcement powers and procedural safeguards. Now, much of the rationale and justification for ex-ante rules is saying basically competition law doesn't act quickly enough. Competition law has all these processes and evidentiary burdens and standards that stifle enforcement effectiveness. And then there's another part of the camp. There's another argument, which is, these things exist for a reason, and they're there to avoid harmful outcomes. And also, if the enforcer is subject to a high burden of proof, it is less likely that that will be overturned subsequently by the judiciary. So that is broadly the project in the background. Now, if you would move to the next slide, I will explain exactly. So the first question of the paper, which I don't know if I've shared with you, but I will on request, or I can just send it to all of you if you're interested, is what do ex-ante regulations actually aim to achieve? What is the underlying rationale? It deals with the whats and whys. I guess that with any law, the first question is, why does this law exist? Why do we need this law? Laws come at a cost. They are not free. So we need to understand why we're passing it. Why is it justified to spend public funds in this? That's where I'm at with this paper. And the questions are, is there a consistent vision of what ex-ante regulations aim to achieve across countries? What is the social and economic harm that is being addressed? Is it the same in the European Union as it is in South Africa? Is it the same in Brazil as it is in Turkey or Germany? My short answer, of course, as always in any research, is yes and no. So if you move to the next slide, I'll try to explain that a bit more. Okay, so the first thing is the goals vary greatly across jurisdictions. In the EU and India, the focus seems to be on fairness and contestability. In other countries like Germany, Turkey, Australia, and UK, there are a lot of terms borrowed from competition law. They talk about fostering competition. They do incide on and insist on economic efficiency, and there are sometimes mentions of fairness, but unlike the EU, where it is specifically stated that the DMA is not a piece of competition legislation, other countries do seem to be more inclined to accept and to leverage traditional concepts and goals from competition law. One interesting thing is that in some countries, like in the US, and perhaps the US is emblematic of what I'm about to say, it's not the only country that does this, but they take concepts from competition law and they slightly change them, right? So if you look at, I believe it's ICOA, the American Innovation and Choice Online Act, the standard for deciding when to act in, I think, 3 out of 8 interventions is material harm to competition. Now that's interesting because under US antitrust law, which protects competition, there is no such thing, to my knowledge, as a material harm to competition standard. So this is taking something familiar, protection of competition, and giving it a little twist, right? Material harm to competition. Now, the American Bar Association did warn that it is risky to take existing concepts and alter them in this way because it can lead to confusion. But I won't anticipate. I'll get to the normative arguments later, which we can discuss. There are other countries where, there are other goals in addition to fairness and economic efficiency and the traditional market failures that some countries like UK seemingly try to address. And that's social and racial equality, economic participation, or social participation. Like one country is South Africa, and to understand why, we also need to understand the South African Competition Act enshrines these goals as part of competition law. Brazil also, interestingly, has certain goals, which I will read now, not in Portuguese. I'll try to translate them, but if I'm not mistaken, Article 4 of Bill 2768 seeks to achieve a liberty of, or freedom of initiative, or economic freedom of free competition, consumer protection, a reduction in social and regional inequalities, and repression of abuse of economic power. I would translate it. I don't know if that's correct, but something along those lines. And an extension of social participation in public discourse. Now, this kind of puts the Brazilian proposal somewhere close to the South African insofar as it tries to attempts to achieve rather social goals too, more openly social and redistributive goals. But then again, if I'm not mistaken, these goals are also reflected, one, in the Constitution, and two, Some of them, but not all of them, are in the Competition Act. I believe that the extension of social participation is not one of the goals of the Competition Act. So once again, it is kind of like competition law. It has some of the same goals within the meaning of Brazilian competition law, because, for example, regional and social inequalities would not be a cognizable goal of antitrust in the US or even in Europe generally. But it adds something else. It adds a little twist, which is social participation in public discourse, for example. Now, before I forget, of course, there's South Korea and Japan, and they're focused on fairness and transparency. Now, broadly, I would characterize this situation as one of heterogeneity, both internally and externally. And what I mean by this is the definitions of the objectives themselves could easily be heterogeneous. Fairness is something that can be interpreted differently in the context of the South Korean Telecommunication Business Act than it could be perhaps in the context of the Digital Markets Act. So many of these goals are a bit amorphous. And the other part is the heterogeneity across the goals, which means that often jurisdictions have slightly different goals or considerably different goals, like social and racial equality from fairness and contestability, or competition and economic efficiency. Now, what's interesting is that the same or largely the same instruments, things such as prohibiting self-preferencing, prohibiting the use of third-party data, sometimes choice screens, all of these things are considered adequate. All these tools are considered adequate to address such a wide variety of goals. Next slide. Now, obviously, this is also related to the nature of the digital market or digital platform ex-ante regulation. Where you put the digital laws or ex-ante rules is likely to also affect the goals and the standards and how they're interpreted. Now, perhaps a little background is relevant. In the European Union, as you know, the Commission has been adamant, has insisted that the Digital Markets Act is not a competition tool. It wasn't passed using Articles 103 and Article 103 and 352 of the Treaty on the Functioning of the European Union, which is what you would use to pass a competition act or a competition tool, rather. Instead, Article 114 was used, which is an article that is used to harmonize laws, which is curious because there were no laws to harmonize. But I guess the logic was, substantively, the argument was this will prevent legal fragmentation. But a more pragmatic interpretation is it is easier to pass the DMA or a regulation through Article 114 than through Articles 103 and 352. But that meant that the European Union henceforth had to defend this as a non-competition tool. So they said this is complementary to competition law, but it's not competition law. So standards like consumer welfare, efficiency, productive efficiency, benefits to consumers don't really matter. They are complementary, but it's not the same thing. Now, the question is, where do we locate ex-ante digital rules in other countries? And what can that tell us about their goals and the nature of such legislation, which is what we're dealing with here. So in some countries, almost paradoxically, like Turkey, it's the same flight. You can keep it there. In some countries, ex-ante rules are explicitly not competition law. That's the EU. But then again, in other countries, they explicitly are part of competition law. So in Germany, Turkey, and South Africa, in Germany, the ex-ante rules, the DMA-style ex-ante rules are in Article 19A of their Competition Act, which means that they're part of competition law. And we can argue whether they fit nicely or not, but they are technically part of competition law, so they pursue the same objectives as German competition law. The case is very similar in Turkey, where the ex-ante rules are embedded or would be embedded, so this is not yet being passed, into Law 4054, which is the their Competition Act. The same would happen in South Africa if the legislation ends up being passed. There is also a third group where ex-ante rules are competition-based, but not technically part of competition law. That is the case in the UK with the Digital Markets, Consumers and Competition Bill, probably in Australia and the US. Now, in Australia, their reports suggest that the goals of their ex-ante rules would very much be in line, or more in line with traditional, with the Australian Competition Act or competition rule, but there would still be formally separate. And there's yet another group in which ex-ante rules would be part of a different statute, such as South Korea, where it's not a separate law like the DMA. It's not a part of the Competition Act. It's not part of a competition-based act that is separate, but they're part of an existing law, such as the Telecommunications Business Act. One reason why this could be a bit perplexing is that ex-ante rules across countries have largely the same obligations and prohibitions, and yet they're placed in very different places and sometimes contradictory places. I wonder how is it possible that the same goals, or the same tools can be used to achieve competition and non-competition based tools. Maybe that's possible. We have heterogeneity also in the competition law, but it's at least something I think to think about. Next slide, please. So this is more of my reading. So what I've said so far is, I think, largely objectively true. And here I'm adding a bit of a layer of my own interpretation. So it's obviously most controversial part, where I try to understand what the rationale and the steps and the logic of the legislator were, what they're trying to address, and how they reached the conclusion that they reached, right? So for me, the trend is this. The starting assumption is that there are severe power imbalances between digital platforms and pretty much everybody else in society, whether it be competing businesses, users, or even governments, right? Somebody's at the door. Do you mind if I go 1 second to just open the door? Just one minute, sorry. Sorry about that. I think they actually left. No, here they are again. Okay, I'll ignore them. So where was I? Yes. So the first assumption is one of severe power imbalances. Once you assume that, once you accept that that exists, it follows that they're going to be, that the outcomes that come out of these imbalances are unfair. They lift some parties and tear others down. That is something that is understood to be unfair, right? Next is, and you can see on the slide, I'm going through this list. Once we accept that this is unfair, we want to make it fair. So these power imbalances lead to unfair outcomes, which we want to correct. That's what fairness means. But of course, it starts from that initial assumption. The issue, of course, is that fairness and similar goals are subjective. What one person considers fair might not be fair by another person. What a business competitor of a digital platform considers to be fair might not be so for the target of that regulation and that fairness obligation. One way in which fairness is restored with ex-ante rules is by reallocating the rents that arise from digital platforms. The logic is, because there are power imbalances that are illegitimate, there are unfair outcomes, and digital platforms accrue more profit and a bigger slice of the pie than they would be entitled to. Because that is unfair, it is legitimate for us to intervene and reallocate those rents and make it easier for either competitors to make money or for consumers to get a better deal, which ultimately means more money in their pockets. There's also, I believe, a clear trend of substituting the usual logic of competition law, which is the protection of competition, for the protection of competitors. Why? Because these competitors are being given a raw deal, and it is legitimate, it is necessary even for the government to step in and to protect them. Lastly, these markets need to be made more contestable. It must be, and here's another riddle. What does contestability mean in the context of ex-ante regulation versus in the context of antitrust? Now, contestability generally increases as barriers to entry decrease. And that is a legitimate way of fostering contestability. But it seems to me, and some of you might disagree, that a lot of these ex-ante rules don't really care if contestability is enhanced by reducing barriers to entry as we would traditionally understand them, or by making the product of the incumbent worse and therefore easier to compete with. Which, again, it's using the logic of competition, but it's slightly thwarting the usual interpretation of what it means to protect competition. Okay, next slide. More commentary from, and this is obviously, again, normative in how I see the situation so far. Again, as I said, it's an ongoing project, so this might change as I look at other pieces of the puzzle. But the first conclusion is that there are many different goals across ex-ante regulations. I think that this part at least is objective. Now, my commentary to that would be, okay, we have often said that countries have different needs, and perhaps, Brazil imitating the model of the EU, considering that the EU has certain strategic goals, such as arguably strategic autonomy, and doesn't have many digital platforms that are going to be subjected to this regulation, perhaps it doesn't make sense to imitate the same model if we accept that that's part of the rationale of the Digital Markets Act. So perhaps differences are okay, they're good. There are issues, however, with that. One is the possibility of regulatory fragmentation, which would increase compliance costs, possibly lead to inconsistent decisions, and maybe even stifle economic growth and investments by raising unpredictability. There's also the issue of, if we have such varied goals, like a repression of abuse of economic power, free competition, consumer protection, it might be difficult to weigh those goals against each other. The broader the goals and the wider their definition, the more discretion the enforcer is going to have to employ, which means that it's possible that the enforcer will not only make mistakes, but that it will ultimately reflect his or her own preferences in terms of what matters most, which of those goals matters most. Not to mention that it is hard to know in advance what an enforcer or how an enforcer will exercise those value judgments. So I guess, to give you an example, I can imagine a situation in which freedom of initiative or consumer protection, such as safety and privacy rules, could lead to social and regional inequalities in Brazil. And maybe you can give me some feedback on that. But that's an instance, a concrete instance, in which the enforcer would have to say, well, I think that in this case, consumer protection matters most. Or alternatively, I think that in this case, safety and privacy or consumer welfare matters most, right? So raises problem number 3, which is how to control that enforcer discretion. And finally, there's an existential question, existential in the sense of the, I guess, philosophy of why these laws exist, which is, how is it possible that the same rules, which I mentioned earlier, things like interoperability, prohibitions of self-preferencing and the such, can pursue goals that are so different and so varied? Next slide, please. Yeah. Okay. Another conclusion that I think is important is the nature of ex-ante regulations. Nobody seems to understand if this is competition law, if it's sector-specific regulation, if it's sector-specific competition law, like I think people like Nicolas Petit have called it, And why does it matter? Why does it matter how we call it or where we put ex ante rules? Right? Maybe it's just a formality? Maybe we shouldn't care about that. But the fact of the matter is, from my perspective, is that where you place the law matters, because the existing law has certain baggage. For example, if you embed ex ante rules into a pre-existing competition act, like the German competition law or the Turkish law 4054, it comes with certain baggage. There are certain expectations and goals. There are standards, there are definitions, there are processes, and there is case law and a whole empirical backdrop that is probably going to influence how those tools are applied and the goals that they pursue. For example, if you embed ex ante rules into existing competition laws, it could also happen that those ex ante rules subvert the system by bringing different or incompatible logic within the same framework. If you have ex ante rules that are protecting competitors in a system that protects competition, that's going to lead to dissonance. That's going to lead to certain fragmentation. Same goes for competition on the merits versus fairness and contestability as understood in the DMA. One can see how that could potentially lead to a chasm within the law. If there is a different framework, let's look at the other scenario. If instead of embedding the ex ante rules in an existing competition act, we make another competition act ex nihilo, right? This could lead to double or triple jeopardy. If there are overlaps, if there are what I referred to previously as competition-like goals with a twist, there could feasibly be an instance in which self-preferencing is covered both by the, say, DMA and by the commission under the competition laws. And in fact, most, if not all, of the prohibitions in Articles 5, 6, and 7 of the DMA come from the case law, come from cases like Google Shopping, come from cases like Amazon, both national and EU level, right? So I think double and triple jeopardy is something that enforcers and legislators moving forward have to take into account. And here is a shameless plug of ICLE. There's a paper by my colleague, Giuseppe Colangelo, on that you might be interested in reading. So, summa summarum, conclusion, depending on where ex ante rules are placed, the definition may vary, right? So fairness under telco regulation, like the Korean Telecommunication Business Act, might not be the same fairness that you have under competition law, assuming that you have fairness in competition law, or under the DMA. These things, fairness and largely subjective definitions like that, could really be colored very differently depending on where they're situated. Next slide. Okay, so this is more of a pet peeve of mine. I always like to look at the broader philosophical implications. That's what my thesis was about. And I do see some trends, and I do see the DMA and DMA style regulation as emblematic of a certain tectonic shift in how we regulate competition and how we interpret the role of competition in society, right? I would say that ex ante regulation is, let me put it differently. The commission says that the DMA is not competition law. I would agree and disagree. Again, I would say that this is both true and untrue. It is true because it is not the traditional competition law, but it is untrue because it is a different type of competition law. It regulates competition. It regulates how companies compete against their rivals, but it does so through other standards that are more based in fairness and contestability as interpreted in the DMA, as I said earlier, than things like competition on the merits, consumer welfare, and economic efficiency. This is again reflective of, I think, broader trends. There is a trend to substitute competition for things like the protection of competitors, contestability, and inclusivity. There is a shift from consumer welfare to more redistributive goals, such as redistribution of rents towards society, SMEs, or complementers in the DMA. I think that the DMA is less likely to foster the growth or the creation of the next big tech thing or the next big Google, as it is to help complementers, companies that are currently active on existing platforms. I would also say that there is, at the most philosophical, broadest level, I think that we are witnessing somewhat of a shift in political economy. And I struggle to give this the right name. It's hard to give labels to these things. I would say that there is maybe a shift from something like market-led economy, although that is an imperfect term, to something as the state being the ultimate ordering power of the economy. Perhaps a better way to put it, and again, this is a contentious term, is there is a shift from neoliberalism to something like economic statecraft, is what the economists called it, I believe. Dirigisme in the social market economy, or some sort of left neoliberalism, which, again, I'm plugging a paper of mine on neoliberalism. And I believe that there are at least two types. And I think that this could be read as a broader shift towards a different way of understanding the role of markets, companies, and broader society today. Okay. In terms of questions, here are some questions that's me and Jeff. Yeah, just a second. Yeah, there we go. My questions to myself and to you, and I guess to the legislators, is will this approach of sector-specific competition, if we call it like that, will it be contained to digital platforms, or will it infect, or maybe infect is not the best word, but will it influence other sectors? Will notions like fairness and contestability, why wouldn't they perhaps apply to other sectors? Is the digital sector so unique? I mean, if you look at the core platform services, they're very different. You have things like cloud computing next to online search, next to video sharing. I struggle to believe that these things have such commonalities and are so different from other sectors that they necessitate a whole nother paradigm shift. So if that is the case, maybe we will see DMA style regulation and logic seep into other areas, maybe even competition law. Anyway, it's too early to say. And then the other one, of course, is how will this fit into the rest of the project? Now, I have to give a caveat, and that's that my conclusions are drawn from from the goals and the rationale of the jurisdictions that I've covered. Maybe when I look at the prohibitions and the exemptions, when I look at other aspects, maybe my conclusions will change. So that's also open. And now finally, I'm open, of course, to any questions and comments.
Thank you very much, Lazar. I'll begin with a question, or just a comment. I think that your project is wonderful and leading to the right questions to be explored. Maybe I would emphasize one aspect is you are focusing on the goals. And I would also, if I could suggest something, is to add a comparison of the diagnosis, the impact analysis in these different countries. I think that not only to understand the rationale of the goals, because maybe you have some goals because those legislators found a problem. Well, there is a problem. We want to reach those goals, but it's not clear what is exactly the diagnosis. What is the problem? What are the reasons for the problem? And this is something then related to that, I had a comment. It seems to me, when you make your presentation, that we are really close to the problem that gave rise to antitrust law, to the very antitrust law. In the beginning of the 20th century, there was this perception, well, the Rockefeller Group is too big, it's too powerful. It has economic power, and now it gets also political power. So something must be done. And the private law was not enough to handle. And so then all the investigations around it and conceptualizations came to the fact that private law is not enough because it's not a relation between competitors. It is competition where the problem is. And so we need new tools, new regulation, a new sort of approach to handle problems in competition, not only among competitors. it seems now that we are facing a similar problem. There are a few companies that can be named. These companies are too big, are too powerful. They have economic power, they have informational power, and antitrust law is not able to handle it. The antitrust interventions were not time effective, so we need a new tool. We need new concept. So then we come. Of course, we cannot regulate in modern law. In the modern law framework, we cannot regulate Rockefeller, as we cannot regulate Meta. We cannot regulate Google. We have to find some abstractions. What is exactly the problem with those companies? It cannot be their position, because this can be the source of this lead dominance could be their efficiency. So what are exactly the problem? The diagnosis, I think it's key. And some generalizations or abstractions appear. Some indicate that the problem is, well, the problem is the size. It doesn't matter if it's Google, if it's Amazon. The size of this platform is the problem. So you come to the concept of gatekeepers. No, the problem is the services. This kind of services will inevitably lead to this problem. And then there is this aspect that you say, well, there are different sorts of service. How can you find a diagnosis that could be applied to all those situations? No, the problem is actually the specific relation between those platforms and other complementors that are other services that are related to them. And so something must be done about it in order to reach common objectives such as fair competition and etc. and etc. So I think that a close look to the diagnosis and comparing those diagnostics, it's really important to really see if we have a common view on what is exactly the problem. Not the problem, not the observation. They are too powerful. Antitrust is not handling it. But what is exactly the problem apart of being these exactly these companies?
Yeah. Oh yeah, great comment. Sorry,
I would
Bianca.
like to complement what Juliano said. When I see your presentation, it just seemed clear to me that DMA and all these legislations are embedded in this new Brundisian movement. You see, it's really the problem is that it's like we have to do something because of the large political scandals involving the big techs like Cambridge Analytics and other problems. So I just want to say that and ask you, what is the real impact on market competition that DMA will bring, if any?
I mean, it's anyone's guess at this stage. I guess the biggest fears are harm to consumers and innovation as these companies struggle to understand if they can compete on the merits or not. But there can also be a perverse impact, which is that because of raising compliance costs, this will actually entrench those companies that are currently dominant. Especially if you look at the Brazilian act, the threshold is very, very, very low. You know more about the Brazilian economy, but it strikes me that 70 million reals, which is about, if I'm not mistaken, $14-15 million US, not very high, not a very high threshold. So could be that it could also capture many smaller companies that are not going to struggle to cover those costs. I guess those are the fears that are most often associated. There is perhaps a broader picture, a broader image, which I think I touched on, which is that this could affect also the way that we interpret competition law and other acts and how we think about competition. It's not about competing efficiently. It's something more social. It's about, I don't know, fairness or protecting SMEs, and that's going to bring confusion. It has always been difficult to differentiate between instances in which you eliminate a competitor fairly or on the merits, and instances in which you use an anti-competitive strategy purely to eliminate and exclude a competitor with no efficiencies involved whatsoever. And the consumer welfare standard helped us to some extent understand that. If we reshuffle the cards now, it could send the wrong message. It could send, at its worst, the message that success is bad, growth is bad, you're capped at a certain level. And I believe that there's a quote by Justice Learned Hand from 1945, where he said, once we encourage companies to compete, we shouldn't turn around and punish those that are successful. I guess that's my biggest fear.
And Lazar, just coming back to my question, I'll put it more objectively. In your first findings on these on the initiatives of these different countries, so you may have found that in Europe there is a clear document of impact analysis making the diagnosis, and it's clear that they identify this is not an antitrust approach. Antitrust is not enough. The problem is about the services and the size. And what about the other countries? Can you find and say something about if there are documents of impact analysis that have been published, and what are they pointing out as the competition problem? There is a competition problem. What is the diagnosis? What's the source of this competition problem?
Yeah, that's interesting. I have to start by saying that not all countries have impact assessments. I believe that Turkey didn't have an impact assessment. I think it didn't have one for the e-commerce law. I'm pretty sure about that one. And I think that it didn't have one for the Competition Act. Now, other countries are taking it slowly. Australia has published, I believe, the 6th interim report. The 5th interim report identifies things like competitive bottlenecks, network effects, tipping markets. Those are the usual claims that are made. Now, the Australian inquiry looks at how these things can entrench a dominant position and harm competition and consumers. That's a competition law framework, right? The DMCC in the UK does something similar. And in fact, I think here's how I see it. The Australian inquiry took the British idea of bespoke interventions and tailored interventions to target specific competitive harm in ways that antitrust might not, but it perfected it, or it's taken it more slowly. The DMCC seems close to completion, and it's not certain whether it's trying to address competitive constraints, bottlenecks, lack of contestability in the antitrust sense, harm to consumers, and how, for example, a dominant company can leverage its position in the online search market to exclude competitors in another one, but within a competition law framework, right? And it's not clear if it's doing that or if it's, again, about fairness, if it's, again, about plurality, having more companies on the market. So I guess to answer your question, generally, the things that are identified are common. There is an imbalance in bargaining power between the platforms and business users. There is an imbalance of bargaining power between the platforms and consumers or final users. There are competitive bottlenecks on markets that are close to tipping or have tipped, which means that it's hard to move or disentrench that company without regulation, especially because of network effects and high switching costs. Now, that is sort of the baseline, but how that is interpreted and the goals that follow from that, they're not always coherent. In some areas, it's about competition, consumers. In others, it's about SMEs. In yet others, it's about social equality, and so on. If you look at, for example, a South African report that came out in July 30th, I believe, they start with citing many of the same reports that the DMA did, the DMCC did, the Furman report, the 2019 EU report on digital platforms, which actually didn't advise for specific ex-ante rules. But they cite many of these studies, but then their recommendations are not exactly the same as, or their goals rather, are not exactly the same. I agree with you 100%. If you want to understand why a solution is advanced by someone, you have to understand what that person thinks that they're addressing, right? And a lot of these legislative proposals or laws seem to be addressing those things that I named, tacitly or explicitly, sometimes with more or less detail. Sometimes the part in which they address these competitive concerns are relatively short compared to the solutions that they propose. So to go back to South Africa, in that case, one of the solutions was that online platforms or digital platforms should give preferential access to South African companies owned by historically disadvantaged people, which is Black people in South Africa. So there, I guess we see how a certain appraisal of a situation that is quite similar can lead to facially different policy recommendations. I guess that would be my my short answer.
Yeah, thank you. Great, very interesting clarifications. Cesar, would you have any questions or criticism?
Okay, I think that Lazar has identified one of the most important problems of Brazilian legislation in general, not only in our bill, because of too many goals, too few tools to handle those goals. I think that it's quite common not only in this bill, but in a lot of laws, legislation in Brazil. You have, you quote a lot of goals that you have. You repeat a lot of constitutional provisions. Not pretty sure if it's something smart to do, but that's how we do those things. And I think it's common with other countries like South Africa, as you mentioned, the question of equality to avoid racism, or there are other goals that all goals you want from public policy purpose. But in the
Cesar,
case
Cesar, let me ask something for you. Sorry for interrupting. You mentioned something important. You said we repeat some constitutional values in our draft bill. Lazar paid attention when they said, "What are the goals in Brazil?" He repeated what is in Article 4, but this not necessarily is exactly the goals that are being pursued, because they are very general.
Yeah, it is. I think it's not. You don't need to conduct yourself on the analysis of the bill on these constitutional provisions that are quite general. I think we do it in a lot of legislations. We repeat a lot of constitutional goals and say, well, we are respecting Constitution. But I really don't see whether this is effective or not. But it's a habit in Brazil, and I see in other countries as well. But the fact is, my point in this bill is I was always very focused on in the case of, well, we are dealing with gatekeepers. Gatekeepers, if there's gatekeepers, there's a gate, and this gate is closed. So we are talking about foreclosure, vertical foreclosure in some sense. That is an antitrust concept, and you have all of those debate, this very conventional debate in antitrust on whether you have foreclosure or not. This debate on Posner, on the Chicago school, and the Brandesian school, that you have foreclosure or not. And but the fact is, the main diagnosis on that I look at the DMA, when they say about gatekeeping is about foreclosure, is about extension of market power from one market to the other, and you have a problem of access. So, and in some moment, the problem is that for me, this diagnosis is quite clear. The diagnostic is very clear, but sometimes I look at to the big techs and to digital markets, and sometimes I'm not pretty sure if I look at gates. I'm looking at gates. Is there gates, closed gates there in Amazon, for instance? Google always says, well, the competition is just a click away. It's quite different from the problems of a harbor, the problems of electricity grid, or the old local loops and telecom, that they are really really essential facilities. There's a gate there, and sometimes these gates are closed. I'm not pretty sure when I look to the digital markets whether this is true for all over the segment. So could you develop something on this matter, Lazar? What about, do you see gates, closed gates in all across all digital markets, or we are confusing this as Bianca has said about size? We're just looking at size. We look at size, a great size, and we look gates, closed gates, because we look giants. We see giants and we see closed gates. Are we confusing this or not? Could you tell me more about this?
Yeah, I think it's been exaggerated to the extent that these markets have gates that are closed. I mean, every market could be said to have some sort of gate, whether it's intermediated by the government or by a private company is a different question. But let's look at the situation in Brazil, for example. I guess that WhatsApp will be one of the core platform services that will be covered. And it's true that WhatsApp is extremely popular and the most popular service in Brazil. But you still have Messenger that has 60 million users. You have Telegram that has 30 million users. You have Instagram with 64 million, Viber with 3 million, Hangouts, not very successful, but still 2 million. There's WeChat, 1 million. There's Kik, 500,000 users. This is one of the markets that would be covered. One of the, you don't call them core platform services, but that's what they're called in the DMA. Are the doors closed? Do they need to be made interoperable? I don't know. And there's a lot of entry and exit recently. If you look at just if I understand correctly, Brazil doesn't even have a strong presence by Amazon. Instead, you have Mercado Libre. And Mercado Libre also has competitors. There is Amazon. There are another set of companies, what was the name? B2W, that has Submarino.com. You have Americanas.com, Shoptime, Magazine Luiza, So Barato, Extra.com Brazil, Casabahia.com.br, Ponto Frio. Probably I butchered the pronunciation, but I think you get it. And of course, also Amazon. Are the gates closed? A lot of these companies entered relatively recently. Doesn't seem to me like a closed market. Doesn't seem to be a public utility sort of market in which there is a natural monopoly and the number of efficient companies is always, most efficient companies only one. So I do think I agree with Bianca that there's a lot of conflation between size and market power. And in fact, perhaps that's where the DMA doesn't look at market power. It doesn't matter what the market power is. It's all size metrics, right? There are qualitative criteria, but those qualitative criteria are assumed or presumed to be fulfilled as long as you have a certain turnover, which is admittedly higher than in Brazil, even in proportion to EU turnover. I think it's much higher than Brazilian, and the number of users. These are all size metrics, and they can't be, or it doesn't seem likely that they can be overturned well, especially not with market power arguments. In fact, the DMA says that relevant market and market power arguments are not germane. So yeah, I agree that there is a bit of the big is bad ethos. And to go back to Juliano's comment or question, if you can boil it down at the most simple, it is kind of rooted in a populist upheaval and antipathy towards size. These companies are too big. Everybody kind of shares that sense, especially ironically after the pandemic, when these companies showed how useful and essential they were to us. And when I say essential, I don't mean in essential facilities terms. And that kind of propelled their regulation. That kind of propelled this picture of them as being ubiquitous and omnipresent. Where I think philosophically I don't agree is that I don't think that companies should be punished just because of their success or their size. Now, I would recommend, if anybody asks me for my opinion, I would recommend for these ex-ante rules to be rooted in economic evidence and in familiar concepts of leveraging of market power, of exclusion, and I would use consumer welfare as the lodestar of the system. I wouldn't give in to the claims and demands that the consumer welfare standard need to be dropped for this. I think that's a mistake. So if anybody's listening, I don't think that ex-ante rules need to be necessarily bad themselves, but I think they should remain rooted in standards that we're familiar with and that work for competition law. And insofar as competition law might not be sufficient, then fine. But you identified a market failure that is familiar, and you're addressing it through specific means. But the coherence of the system remains intact. That's, I guess, what I would say.
I have one last question. We are a little bit ahead of time, but I would like to hear you on that. So your research is actually raises a question mark on the need of effective ex-ante regulation, and it seems that there is, at least in Europe, the view that antitrust tools are not effective, and one of the problems was time. The interventions were not time effective. But if this is the problem, there may be other tools that are not material, not substantial about the diagnosis, the methodology, the tools, but it is procedural. Well, maybe we should do something about the procedure of investigation and enforcement of antitrust law that would make intervention time effective, because these markets are too dynamic and exclusion can happen really fast. So what do you think about it?
Yeah, a preliminary comment that I would make is I don't think enforcement is a goal in itself. Just because you've enforced something against a company doesn't mean that enforcement is successful and that it protects the public interest. So I'm in favor of making enforcement easier as long as it's also more successful, right? And the flip side of the argument that these markets are rapidly changing and dynamic, many markets are rapidly changing and dynamic. And that also means that intervention can also just as easily thwart that dynamism. So that's something that is not usually part of the conversation in Europe. In Europe, the kind of ethos that the Commission has right now, regulation can do no harm. There are no sort of not sufficient cognizable costs that are considered in that context. I do think that the fact that, as I mentioned earlier, that most, if not all, of the prohibitions that are contemplated under the DMA are part of either a case that is being decided in antitrust or an ongoing case, means that these things are theoretically possible. These are theories of harm that could be invoked as long as you can prove an antitrust offense and harm to consumer welfare. And the Commission seemed to believe that you could, otherwise they wouldn't have started these cases, by the way, many of which have actually succeeded in front of the courts. There are ways of addressing this issue, assuming that it's really an issue that these markets, for some reason, they need to be like, decisions have to come quicker. There are things such as the reversal of the burden of proof. There are presumptions that can be incorporated in antitrust. But what's kind of funny to me is that even a cartel can be exempted theoretically under Article 1013, but self-preferencing can't under the DMA, except for some privacy and security considerations that are very, very narrow. I think that this is just enforcement for the sake of enforcement, of doing something about these companies. I don't think that's good policy. I don't think that's good law. And I do think that there are ways that antitrust could transform or adapt. It is shown to be an adaptive tool to address market failures in these markets, insofar as they harm competition and consumers.
Okay, thank you very much, Lazar. It was really illuminating, and I think that we are going to carry these inputs to our next lives. We are already in the end of the year, but we are trying to make a last one, inviting Deputy Annie Ortiz, who is in charge of the bill in the Chamber of Deputies. So I hope we succeed in doing that. So we have our last live in the year with this contribution and approach to understand better what are the designs of our bill. You are invited to this last one, and to the others one. I know that you know Spanish, so something you may grasp, and in the meantime, maybe you can learn Portuguese.
Yeah, I mean, you're too optimistic about my language skills, but I would love to. It's a great language, and I'd like to thank you all. It has been a great experience. I've loved talking to all of you. There's some great questions. And I will definitely follow legal grounds. And I'd love to hear what Deputy Annie Ortiz, that is very much the one who is behind this now, if I'm not mistaken, has to say, in her opinion, of the state of the bill.
Yes, she's the rapporteur.
The rapporteur, that's right, yeah.
Thank you very much, Lazar. Bianca, you may close our session now.
Lazar, thank you very much. It was great, very interesting insights. And now I'll turn to Portuguese. I hope you come back with us in other lives.
Absolutely.
And very well, a very good weekend for you.
In other lives with me, not other lives. Although your company is very
lives,
pleasure.
you don't know. You don't know. Maybe in other lives also.
I hope if reincarnation is a thing, I don't know that I want to be an antitrust lawyer again. It's been great. But there's other things. Formula One driver, it's much to do.
But it will be, for sure, you'll have good insights, even in other fields.
Yeah, totally.
Ok? So, convidamos todos os interessados em aprofundar seus conhecimentos sobre os mercados digitais a acessarem o conteúdo inédito que é disponibilizado pelo nosso Núcleo de Mercados Digitais por meio do site www.legalgroundsinstitute.com. Nesse portal é sempre possível ter acesso a muitas informações exclusivas, podcasts, gravações dos nossos encontros e atualizações sobre essa discussão, que é de grande relevância tanto para estudantes quanto para pesquisadores, para profissionais que buscam compreender essas dinâmicas do mercado digital e da regulação nessa nova economia digital. Muito obrigado, bom final de semana a todos e voltamos logo nas nossas redes sociais com informações sobre a próxima live com a deputada Annie Ortiz. Um abraço, bom final de semana a todos.
Thank you. Bye-bye.